Okay. So, good evening, everyone, and thank you so much for taking out the time for joining today's webinar on the rise of global parliamentary hearings and investigations. In recent years, we have seen a marked increase in public scrutiny of businesses through legislative and inquiry forums, especially in the US, UK, and EU, and the ripple effects can be seen cross-border and, of course, they're immediate. So, today's discussion is meant to be practical, focusing on what organizations can do to prepare. To set the scene, I'll invite Dr. Lalit Bhasin to share a few opening remarks on why this topic matters right now. Now, although Dr. Bhasin needs no introduction and his list of achievements is quite long, I'll hardly be able to cover all of it during this short webinar. But in brief, he's an eminent lawyer. He's the founder of Bhasin and Co, a leading law firm in India, and also the former national president of the Indo-American Chamber of Commerce. Dr. Bhasin, over to you.
Thank you, Susannah, for your very generous opening remarks and introduction. Yeah, I happen to chair, the Society of Indian Law Firms, of which Khaitan Co are very, very distinguished partners, and they are contributing significantly. And this particular webinar is mainly due to the efforts of Vanita Bhargava and Ajay Bhargava, who are the faces of Khaitan Co in this part of the country.
Yes.
So it's a privilege for me to participate in this very important and significant webinar. Although the theme of the webinar does not seem to match the legislation and the framework existing in India with regard to hearings and investigations. Because in India, the Indian Parliament is not an investigating agency and it does not indulge in public hearings. The function of the Parliament is mainly to enact laws. Laws, which are there in the Union list of Schedule 7 of our Constitution, that where the Parliament can make laws. Then there is a second list where the state legislatures can make laws. And then thirdly, there is a concurrent list. So the activities or the main role of the Parliament under our Constitution is to enact appropriate laws. But having said that, there are also certain circumstances, which may go outside their legislative function. Like, for instance, impeachment of the judges of the Supreme Court or High Court, or impeachment of the president or the vice president. There an elaborate procedure is made out, but then that would not tantamount to being a public hearing of anything. That is confined to the legislatures and the legislators who are participating in those. And recently, we have had some occasion where judges of the Supreme Court were impeached, or at least the process was started, including a judge of the High Court also. Apart from that, the Parliament also has some consultative committees, which are there, which are statutory in nature, in which the Parliament seeks the advice and opinion of experts while enacting certain legislation. There the role of the outsiders come in, who are experts, who may not be members of Parliament. And that is another facet of parliamentary functioning in India. Again, having said that, it doesn't mean that there is no scope for any public hearing. Public hearings also take place, but outside the scope of the Parliament. For instance, when emergency in India was imposed, and it was alleged that certain excesses were committed by the then government, from 1973 till 77 or so, then a commission was set up, you see, by the government, and that was the J.C. Shah, Honorable Justice J.C. Shah Commission, which inquired into the excesses committed during that. Other than that, we have had several commissions of inquiries on important matters, particularly with regard to tragedies which take place. For instance, we have had air crashes, you see, where Air India aircraft were victims of terrorist attacks. You see, the Kanishka air crash, and then uh, in Japan, you see, there were attacks. So there also courts of inquiries were set up in public domain with where either the retired judges or even sitting judges were asked to do the investigation as to the cause of what has happened. But this present seminar is focused mainly on the corporate world and what you see it faces. And in this connection, I find that many Indian companies, including in sectors such as pharmaceuticals, technology, manufacturing, and heavy industry, have been called to explain their manufacturing and explain their practices and decisions in the foreign fora. And even where a company is not formally summoned, it can be drawn into wider debates about supply chain standards, labor practices, child labor employment, data and AI governance, environmental control commitments, sanctions, and anti-corruption compliances, particularly in the US, you see, and in Europe. That is why today's session, this webinar, is designed to be practical. We will focus on what business leaders and boards should do before they ever receive a notice to appear. How do you scan the horizon for issues that may attract public or congressional attention? How do you organize internally to respond effectively across legal, compliance, risk, communications, and leadership teams? We are fortunate to have an excellent panel for this discussion. We will hear from experts who have advised organizations in these settings, including on US congressional hearings, UK Select Committee appearances, and inquiries. And we will also bring the discussion back to what it means for Indian companies operating globally. So in this context, this is a very important initiative taken by, you see, Jenner and Block, which supported by Khaitan Co. So I'm looking forward myself to views of the experts on these very important aspects. Essentially, these relate to functioning of Indian companies as viewed by the foreign corporates, you see, and foreign investigating agencies, and that is why the public hearings take place. I wish all the best to the discussion. So I take leave of you. Thank you. Thank you very much, Susannah.
Thank you so much, sir. Like you said, we have a great panel today, and it's my pleasure now to introduce the panelists. First up is Ms. Joanna Ludlam. She's a partner with Jenner and Block. She's based out of London. She's the chair of the London Public Law and Crisis Management Practice. She's the co-chair of the firm's Global Hearing Preparation and Global Crisis Management and Strategic Risk Practices. And she also co-chairs the firm's Investigation Department. Our second panelist is Mr. Sam Ungar. He's a partner with Jenner and Block, but based out of the DC office. He's also the co-chair of the firm's Global Hearing Preparation Practice. As is evident, both Joanna and Sam have extensive experience with parliamentary hearings and legislative investigations. Our third panelist is Miss Vanita Bhargava. She's a senior partner with Khaitan Co and is based out of the Delhi NCR office. She's part of the disputes practice. She has extensive expertise in constitutional laws, taxation laws, environment laws, civil laws, corporate laws, mining laws, forest laws, shareholders disputes, arbitration, banking laws, insolvency matters. And she practices across various forums. As a colleague, I can assure you that she's stellar. And like Mr. Bhasin said, Mr. Ajay Bhargava and Vanita Bhargava are the face of the practice of Khaitan disputes. So thank you to all our panelists for agreeing to be part of this. Without further ado, let's start. So how many of you have operations in the US, UK, or EU? And secondly, have you ever thought about what happens if you're called before the Congress or the Parliament? That's exactly what we are unpacking today. Joanna, let's start with the basics. When we say public hearings in this context, what are we actually referring to?
Thanks very much, Susannah, and thank you for the lovely welcome. I should also add that we have actually also got Mr. Mukhopadhyay from the Hinduja Group, who's joined us as well, and he will be sharing his insights as an in-house counsel. So I thought I should just mention. So
Sure.
what do we mean by public hearings? Well, public hearings are very different to the private litigation that you have in the courts between a private individual and another private individual or corporation. What we are talking about here is hearings by legislative bodies. So in the UK, it's a hearing by a parliament, a parliamentary committee. In the US, it's a congressional hearing or investigation. And there are similar types of hearings in different legislatures around the world. And just to add, in the UK, there's an additional curiosity, which is we also have a concept of a public inquiry. And the public inquiry is not a legislative hearing, it's a formal government established investigation. And these are often used to look into a specific event or a major public concern. So, for example, there is a large UK public inquiry at the moment into the COVID-19 pandemic, and there has been a very high profile public inquiry into a large fire which happened in London several years ago, and which tragically took the lives of a number of people. And there have been inquiries about the kinds of building standards that were used in the industry in that particular inquiry. So the difference between these hearings and a court legislature is that not only is the procedure different, but also the amount of public and media scrutiny is very different. And there has been a documented increase in both the frequency and the scope of select committee activity, the congressional hearings activity, and also increased media coverage. So, for example, the UK House of Lords Liaison Committee noted that between 2023 and 2024, there was almost a doubling of the number of parliamentary select committee hearings and the media coverage of those as compared with 2022. So this is something that we're seeing on the rise. And these hearings are being increasingly used to hold major corporations to account. So it's a corporate accountability tool. And just to flag, Indian companies are already facing these risks. So Tata Steel has been the subject of a number of parliamentary committee hearings in the UK, and its executive have been called to give evidence. And the Indian pharmaceutical industry has been the subject of extensive congressional scrutiny in the United States. And the risks of these hearings are really serious. So there's a really notorious example from a number of years ago where 7 chief executives of large tobacco companies testified to a US congressional committee that nicotine was not addictive. And 2 years later, they were all under federal investigation for perjury on account of this testimony. And so the risks are significant from a legal point of view, but also from a reputational point of view. And I think what's a particular feature about these kinds of hearings is that we understand that in India, if there is scrutiny by a parliamentary committee, it would usually take place in private. Whereas in the US and the UK in particular, these congressional and parliamentary hearings are very much public. And indeed, the parliamentarians who participate in them use them as a basis for grandstanding and publicising, their political agendas. So this means that we live in a say it once, defend it everywhere kind of world. What you say in one jurisdiction is fast televised across the world in different jurisdictions, and they can also go viral on social media. So the bottom line is this is now a risk of doing business in the US and the UK and also elsewhere. And for Indian businesses that are accustomed to private interactions, this shift to public televised testimony when operating in Western markets represents a really fundamental change in risk profile, as I said, not just legal, but also commercial and reputational.
Sure. And Sam, building on that, why has this become such a cross-border issue for businesses?
Well, thank you for the question, and thank you again for inviting me, and it's a pleasure to be on the panel here with you and all of my distinguished co-panelists. This is a cross-border issue really because of the nature of the world in the 21st century, right? Business is ever more global, even considering the current trade issues, and it's becoming increasingly evident that the people who make policy aren't content to limit their field of view to what's happening in their own countries anymore. If you couple that with the nature of the modern media machine, and particularly social media, it means that a statement made in a, public hearing before Congress here in Washington can spark regulatory interest in, Brussels or Paris, London or Berlin or elsewhere across the world within a matter of hours. And, even when legal standards differ from country to country, in many, many countries, driven, I think, in no small part by the frictionless communication between and across nations, there's this converging, sense of expectation for transparency and accountability, even in jurisdictions where that wasn't always the case. We're also seeing more and more cross-border coordination by relevant policymakers themselves, who are all talking to each other these days. I think about this in terms of US, EU, other national regulators. And we're seeing this especially on issues like anti-corruption, on privacy, and, increasingly on AI, which I think is going to be, a next frontier, and certainly is not an issue that respects borders in many respects. So I think I would say that operating, in limited jurisdictions, even if you're only in one country, it doesn't necessarily shield a company from scrutiny in other places anymore. A global reputational risk is now a permanent business reality. And so I would emphasize something that Joanna just said, which is, if you're speaking on behalf of your business in one of these proceedings, if you say it once somewhere, it's really important to be prepared to defend it everywhere.
Understood. Great. So, we've covered what these hearings are, why they travel. The next important question is what triggers them. Joanna, what themes or issues are you seeing legislators, governments, and inquiry bodies most focused on right now? And Sam, once Joanna sets that out, I'd love to hear your perspective on how the focus has shifted over time.
Thank you, Susannah. So as I said, we're seeing a rise in the scope and frequency of these public hearings. But we're also seeing a trend that they are becoming more adversarial. They are a permanent feature of the parliamentary calendar. It's an ongoing scrutiny. So there's a series of hearings that the parliaments or Congress like to follow. Increasingly, we're seeing committees choosing their own topics. So individual members of parliament can decide, I'm interested in this or I'm interested in that. And they have a political agenda or a bee in their bonnet about what they want to talk about. And we're seeing that materialize as a systematic agenda item on these kinds of hearings. And the other thing that we're seeing is the nature of the questioning. So bear in mind that when you're going to give evidence at these kind of hearings, you're not protected by a legal team and by your leading counsel who will have his own or her own regulatory rules to follow about the way that they ask questions and what you're allowed to cross-examine on and what you're not. This is basically a free-for-all where any question is fine. You're not protected. If you refuse to answer, then the way in which you refuse can be spun and broadcast in a different way. So these are the kinds of trends in the process that we're really seeing. And then in terms of the kinds of examples that we're seeing the committees being interested in. Well, first of all, the current hot topics, as we heard in the introduction, include labour rights and standards, including in global supply chains. So there's a lot of scrutiny on the Far East and Asian supply chains of UK and US companies. Employment rights, so workers' protections, including the trend of hiring freelancers, the gig economy. We're seeing a big focus on energy, clean energy, and energy security, building safety, online safety, online harms, children protections by big technology companies, social media, AI. Supply chain transparency and labour standards are particularly relevant for Indian businesses who have manufacturing operations or outsourcing relationships, as we've seen with apparel and technology companies. And legislators are starting to demand transparency about what happens at every level of your supply chain. So Indian companies with global operations face questions not just about their own practices, but also about their suppliers, their contractors, and their business partners worldwide. And then there's one final thing that I want to say about the trends that we're seeing, and that's that there is an increasing link between public hearings and ongoing litigation. And we had a recent example of Shine, the Chinese apparel company, which was called before the UK Business and Trade Select Committee. And the committee members used frequent reference to a dossier that had been prepared by one of the very aggressive UK claimant law firms that they clearly behind the scenes provided to the committee members with content that they could ask questions about. And then you often see the evidence that has been given in these committees being cited back in private law proceedings. So earlier I referenced a big UK public inquiry into a large fire in London that happened. And we're seeing evidence from that public inquiry being cited in both civil and criminal lawsuits that are being brought against the builders and construction companies that were involved in putting that building that tower of apartments. So there is increasingly that link, which is an unnerving experience. But I'll hand over to Sam to continue with your second question.
Thanks, Joe. And, I've spent a lot of time thinking about how we got to where we are today, because sitting here in Washington, the United States Congress has long had a fact-finding function to consider potential legislation, and that has involved public hearings to investigate matters of interest by congressional committees for many years. And the way that often manifested was in what I would call big ticket, blockbuster, event-driven congressional hearings in response to major events, at least in theory, to consider what Congress might do about them. So a rail car carrying chemicals might explode and contaminate a town, and the CEO would be called in front of Congress and the country to explain why. Or, the Enron executives were called in 2002 to explain the accounting fraud that collapsed their company. And, there were these big hearings with all the big three American automakers in 2008 during the economic crisis when they were coming in to ask for access to taxpayer funds for economic relief. And so we've always had these big hearings, but what's really changed is that Congress, I think, realized in the last few years that it can go a lot further with these hearings and hold a lot more of them, even without those kinds of giant news stories that, inherently drive coverage. And they can use these hearings to not just scrutinize scandals, but to look at ordinary and entirely, corporate decisions that just they don't agree with, just to try to change the company's behavior, including purely economic decisions like how they price their goods and services, the kind of thing you would ordinarily expect to see legislation on. And In the United States, I think partisan gridlock here on Capitol Hill makes it increasingly difficult to pass laws, as I'm sure those of you who've observed the American political system have seen. But the majority party that controls a congressional committee can call a hearing on anything and use its subpoena power, the power to compel private witnesses to come and attend, to use public pressure to get them to make changes without ever needing to pass a law. And as they move on from what that means from a corporate business perspective, they can also look at corporate culture and corporate behavior too. And so we're seeing companies through this process find themselves pulled into broader societal debates, from AI to ESG to workplace culture, whether they want to be or not. And we see those in hearings too. One other thing I would say, sitting here in DC, from the American vantage point, these hearings are notoriously aggressive and theatrical. And one thing that I'm seeing, is that these tactics are spreading. We're used to seeing even more cordial forums like parliamentary bodies becoming more aggressive in these kinds of hearings. I think taking a lesson from what they've seen in the United States. And so, when we're coming to the table, seeing how these peculiarly American political spectacles have evolved and the way they've spread and been adopted by other politicians around the world. I spend a lot of time thinking about how to help clients be prepared for them wherever they're happening.
Understood. Thank you so much, both. I think this paints a clear picture of the issues driving scrutiny and why companies can get pulled into wider societal debates quite quickly. But now let's bring this closer to home. Coming to you, Vanita. India has actually chosen a very different model of regulatory engagement, typically private rather than public. As Indian companies operate globally and face Western-style public hearings, what are the advantages and challenges you think of this cultural difference? And do you think should Indian companies advocate for India to maintain its approach or adapt to Western norms?
Thank you. Thank you so much, Susannah. And it's a privilege to share this panel with my distinguished co-panelists. Yes, like Joanna said, and like you mentioned, India's approach to regulatory engagement has traditionally been more private and file-driven. The interactions are mostly closed-door, focuses on compliance, not public accountability, and there's a limited media or political exposure. Now, of course, that has two advantages. First, it often allows for course correction without public escalation, like what Sam and Joanna also mentioned with the social media now, with what it is. Second, it reduces the risk of headline-driven distortion, where a complex fact pattern gets simplified by the media into a single soundbite before due process plays out. Further, private engagement allows frank discussion and negotiated regulatory outcomes rather than adversarial televised questioning, typical of US congressional or UK Select Committee hearings. Now, the challenge is that leaders raised in that environment are not always prepared, for Western legislative scrutiny, which is public, political, and performance heavy. And I would just give a live example. I mean, it was mentioned that, in India, mostly the committees are formed for legislations, but we also have come across where, Parliamentary Committee of Petitions, they have called companies for, environmental violations, etc. And we have seen that, there's a Parliamentary Committee of Petitions can examine petitions related to bills and matter of general public interest, which widens the scope. And it can even hold hearings for evidence and summon representatives. So to that extent, even though the proceedings are private, the Indian companies do have some sense of what they can expect, in parliamentary hearings. And there's a very small scope that if there is any matter which is within the cognizance of a court of law or for which remedy is available outside the scope of committee, those matters can fall out of the parliamentary hearings. Now, should India stay private or go public? That was a second question. So, I would not frame it as a binary. India can keep the benefits of its model while also recognizing that Indian companies operating abroad must adapt to the norms of the forum they are in. The practical position is do not try to export Indian assumptions into Western hearings and instead build internal readiness so you can operate credibly in both of the environments. And some of the readiness is common in both public and private hearings. For example, committee, you have to cooperate early, you have to prepare witnesses, seek legal advice on privilege, maintain record and follow up. Thank you.
Understood. So as I understand, it's not an either or, and I think Indian companies need the ability to operate credibly in both environments. Moving on, we're also delighted to be joined by Mr. Abhijit Mukhopadhyay. He is the president and GC of the Hinduja Group, a large Indian conglomerate having global operations. Mr. Mukhopadhyay, delighted to have you here and thank you for joining.
Thank you.
My question to you is, as a GC of a company with a global footprint, what do you think were the typical challenges facing Indian companies a few years ago when they were trying to enter highly scrutinized markets, which now have been largely addressed?
Well, thank you for having me. Susannah, before I get into the details, I was just hearing the debate. It's really fantastic. But I would not like to compare India with other democracies in US or UK or even in the EU. Look at the size of the country. There is a country of 1.4 billion people. There are more than 1.5 million companies operating in India. Okay. There are both houses of parliament. More than 800 MPs are sitting in the both houses of parliament. So if you see the, breadth and dimension and depth of the whole thing, I won't be able to give a straight answer whether should we really bring Western way of working or should we not bring. It's very difficult. India has got a constitution. It is very clear that what the federal government can do and what the state governments can do. And if I'm not mistaken, there are 26 states available. Some of them are bigger than even the United Kingdom. And there are 3 territories controlled by the government of India. If you ask me why I'm sharing all these things, then you will be able to understand that there is no one straightforward answer whether the Indian companies can be brought under parliamentary jurisdictions or not. It operates in a different way. The system that India has adopted, you have got regulatory bodies everywhere. So if there is any malfunctioning, if there is any kind of, investigation, if companies are not working properly, if you have got any complaint against them, there is a regulatory body which does that, whether it is in the banking, whether it is in the company law area, whether it is in financial area. There are regulatory bodies. Listing companies, we have got SEBIs. So if there is an issue where you need to understand as a public what's happening, you don't go to the parliament, like the companies also don't go to the parliament. You have got the regulatory body, they will call you, you can make your complaint there, and probably matters will be settled there. Having said that, as a parliament, as a member of parliament, you are entitled to ask questions, very specific start questions, unstart questions in the parliament. For that, there is a process available. So unless and until you appear, in the parliament at the 0 hour, otherwise you have to follow a process. You are entitled to ask questions about any particular company, about their whatever activities they are doing. When I was in India, I myself worked in companies where lots of parliamentary questions used to come, but then those questions are replied to not by the executives, but by the minister in charge in the parliament. In the parliament, there is a decorum that you cannot raise questions of a particular individual, CEO, or anything which cannot be replied by the company. That kind of decorum exists. I can't raise a question about the Tata Sons chairman in the parliament. It is not possible. There is a process there because he is not represented by anybody in the parliament. So the functioning is slightly different in India. So therefore, if you ask any Indian companies operating primarily in India, that are you aware of this kind of parliamentary proceedings and all, I think they will not be able to give you a proper answer because the India does not have that kind of culture in that part of the world. Having come to the second part of your question, now the Indian companies are going global. So in such an event, they have to play by the rule book of the global standards, whether it is corporate governance, whether it is parliamentary scrutiny, everything. Now, if I want to, set up a company or acquire a company in the EU, there are very strict human rights laws which I have to comply with. I can't say in India it is not really prevalent, so I'm not going to do it. You have to follow. Otherwise, or the issue of modern slavery. These are quite, unheard of in the Indian context, strictly speaking. But in the Western world, in the American world, these things are very, very important. So you have to play by the rule book of the Western, countries, Western laws, rules, and regulations. Coming back to Indian companies operating globally, and now they are there everywhere. I'm sure you are aware. In the UK, there are more than 1,100 companies operating in the UK alone, and their global turnover in the UK is 53 billion pound. So you have to play by the rules and regulations of the Western, system. So therefore, if you ask that even in the global market, global footprints, whichever Indian companies are operating, are they really very much prepared to, deal with the parliamentary investigations, queries, etc.? I don't think so. Tata's is an exemption. The pharmaceutical companies is an exception. I myself worked in pharmaceutical companies. I know how the FDA in the US operates and all. So definitely in the Indian scenario, it is not there. But Indian companies operating abroad, this is high time they should also prepare themselves. Like, for example, I don't know in big companies, who is responsible for handling this kind of matter. Perhaps the moment something comes up, we will call the publicity person, we will call the strategist. So I don't think that we have ever thought of it unless and until very big conglomerates like Tata's, etc. do it. Still, we are not prepared ourselves to really face any kind of parliamentary investigations. Now, normally, having said that, there are select committees of parliament in India also. Even I myself attended some of them. When new law comes, if they want to understand the law better, they can call the chambers of commerce and you can go there and explain. But that is not connected with any investigation, etc. But in the Western hemisphere, it is completely different. So we should be prepared for that. Now, my final point will be that I don't know, do they really accept publicity? And India, that is another problem. There are 100 political parties. So therefore, even constitution of parliamentary committee itself, I'm seeing Dr. Bhasin, such a respected figure. He knows better than me that what kind of issues come up when even a parliamentary committee is set up by the speaker. So there are issues, which is not the case in case of UK or even in US, where we find only 2 parties, 3 parties, parliamentary democracy. But my final point will be that, does it really help in any way? I don't know. It is theatrics. Samuel is very right, no doubt about it, especially in the US. It is more of a drama than anything else. Here also in the UK, it is not drama, it is more serious. But then when we ultimately, see the results, COVID or even public inquiry on the Iraq war, or the latest one is the West Midlands Police, what they have done. I really am not very sure whether this kind of parliamentary investigation, whether it brings any typical results to the common public. I'm not sure. Maybe, in some cases, some benefits might have been earned, like, in the Horizon case, in the post office scandal, parliamentary committee, they investigated and they played a big role. But in most of the time, we found as a common citizen of any country that as a common citizen, I'm really not benefited. That's my general view.
Thank you, Mr. Mukhopadhyay. So as Mr. Mukhopadhyay said, he thinks that a lot of countries operating globally are not prepared for these hearings. So the next question is, what should leaders actually do when a hearing is on the horizon? Sam and Joanna, what will be your key recommendations for business leaders preparing to give evidence to a public hearing? And what are the common missteps you see and how they can be avoided? And in between, if you can also answer Mr. Mukhopadhyay's question, that how do you think the common public is being affected by these hearings in any way?
Well, thank you for that. And Mr. Mukhopadhyay, I mean, that was extremely interesting and insightful to hear that perspective. And, sort of, following on one of your points about, the publicity spectacle that this can be, I would just emphasize from our perspective, the naturally heightened stakes of a public proceeding, right? Where, attention has to be given to the way that everyone is incentivized to act differently, given the attention that is coming on something like this. So, when we think about preparation, it's not just knowing the facts. It's not just knowing what your business has done, and that's the baseline. But it's not enough. It's about you gotta if you want to perform, in this kind of proceeding, it's about understanding what are the broader political narratives that the leading policymakers and the regulators, the people participating in these hearings, are pursuing. You need to understand their perspectives and their motivations. Oftentimes it's an electoral motivation. So you could try to mitigate their concerns as effectively as possible and seem on side as opposed to offside. And so, I think executives, and it oftentimes is executives who are, coming into these proceedings, I think you need to expect questions that go to your company and then go beyond your company to be asked to opine on industry-wide practices and emerging technologies and even broader societal issues, what any one given issue says about the broader state of our society. And just because you've been called to testify about the prices your company is charging or your staffing practices doesn't mean that, that's what it's going to be limited to. And, in many countries, we've seen politicians realize, how great these hearings can be, what an opportunity they present to extract broader information or even concessions, about entire industries that they can use to fuel future regulation or, frankly, future political campaigns and investigations. And, you can also, and I think should also, assume that regulators are watching, that activists are watching, that the media is watching wherever you're testifying and around the world. Especially, if you are, being asked to come in and give evidence, in a jurisdiction that's considered to be a leader on a given issue and that other countries are interested in emulating. Australia is a leader on online safety. The EU is a leader on data privacy. Even Singapore is a leader on something like cryptocurrency regulation. And so if you're coming into a forum like that where everyone else is going to be paying attention, I do think that there are substantive things that sometimes come out of these, in the right forums at the right time. But you're absolutely right that when the lights are brightest and there's the most attention being paid to these, there's a big theatrical element to it, and there's got to be preparation for it. Otherwise, things can escalate globally and very, very quickly. Joe, I don't know if there's more you wanted to add on that.
Yeah, I mean, I agree that if you're not prepared, things can escalate quickly. And I would argue that this kind of risk needs to be on an organization's risk register. And, we also in the UK and in the US have regulatory risk, and the regulators have their own ability to scrutinize, investigate, enforce, etc. But this is slightly different, and it's apart from the regulatory risk. And so having this kind of risk on a risk register, being ready, and by that I mean scanning the horizon, being familiar with what are the current topics that these committees are really interested in. Are there people in my industry that are being called to give evidence? And therefore, is it likely that I will also be called to give evidence? And if I am called to give evidence, what do I need to know about the way we operate ourselves in order to be prepared for that? And I think, there is a degree of, so I would agree with Mr. Mukhopadhyay's question about whether there is a broader societal benefit of these kind of hearings. And I would say it depends. I mean, we have seen a huge amount of money being spent in the UK on public inquiries where a very damning report is produced by an eminent judge, and then a lot of money is spent, but then nothing else happens. And really the whole benefit of that inquiry has been to allow members of the public who are affected by an incident to vent and unload their anxieties and emotions about it, but ultimately, does anything change? But by contrast, we've seen examples of legislative policy being influenced by evidence that's been given in these UK select committee hearings before Parliament. So, for example, around workers' rights, a lot of the evidence that has been given by executives has influenced the direction of travel of the Employment Rights Bill, which is coming into law soon. And so, for example, there's already an offence of failing to prevent sexual harassment, a corporate liability offence, because of scrutiny of big corporates who have not got a handle on sexual harassment issues within their organisations. And the legislatives have heard that and thought, well, we need a law then. If you can't get control of it without the incentive of a law, we'll give you one, and then you will be incentivized. So to a degree, these hearings have had some effect depending on the topic. I think that, finally, in terms of preparing for them, there needs to be a multidisciplinary approach to them. So I think for a long while, organisations who were being called, when these committees started to scrutinise corporates and their conduct and behaviours, the corporations responding to that scrutiny saw this as a PR issue. They would get their external PR people to come in and do a mock select committee hearing. But as I mentioned earlier, these hearings are increasingly being used as a way of extracting evidence that then provides the foundation for civil and criminal claims. So you need legal advice, because what you don't want to be doing is making a concession in these hearings that hands someone on a plate a roadmap to liability for your organisation. So you need legal advice, you need political advice, you need commercial considerations, and you need reputational advice. And I think having a multidisciplinary approach to these risks is absolutely fundamental.
True. One theme that's already come through in these forums is that these forums have very different styles and expectations. So my question is again to you, Sam and Joanna. How should companies adapt witness preparation across different cultural and political environments? For example, US congressional hearings versus UK Select Committee hearings versus EU Parliament, and also when you compare it with what Indian executives may be used to at home.
I'm happy to take that first, and I'd welcome perspectives on India. I'll weigh in based on sort of what I understand and have heard on the panel so far. But from what I see, there's a really careful balancing act that's required here. Even outside of India, forums that may all seem Western, nevertheless have very different styles. And it can chafe and antagonize if you're not calibrating for whatever one you're in. So just to give two examples, we've talked about how the United States is adversarial and theatrical and fast moving in a lot of ways. There are forums in Brussels that, may bear some surface sort of similarities structurally to what the US looks like, but it's formal and it's slower and it's really sharp on regulatory matters, and performing in front of a Brussels tribunal, hearing or workshop as though you're in front of a congressional committee won't work the same way, even if ultimately, you have the same goal in both. At the same time, in this increasingly globalized world we've been talking about, with everyone who cares about the issue watching, no matter where they are on the planet, it does mean that if you say it once, we said this before, but it's true, you have to defend it everywhere. Even if you only said it in a certain way in order to try to offend folks in the jurisdiction where you happen to be sitting at the time. Your audience goes beyond, whoever is right in front of you at that moment. And so I think the best thing to think about is, how can you adjust your demeanor, your tone, even, elements of what you're saying, while still maintaining, that message discipline across forums if you're operating cross-jurisdictionally. And, cultural agility is non-negotiable, but your core corporate integrity and the principles, that you are trying to advance have to stay consistent. I spend a lot of time in South Korea, and there's a real norm there of, expecting an apology for business conduct that, parliamentarians may not approve of, even if that conduct is legal or consistent with your, global practices elsewhere. And so it's a very fine needle that you have to thread of being sensitive to, those cultural particularities while maintaining that consistent message. And so, I would encourage Indian business leaders who may be accustomed to a different style of interaction with, many, many regulators and lots of different parliamentarians, to think about, how to adapt to this, nature of Western legislative hearings if you're at risk of being called there, without damaging your position back home.
And I would add that equally, when we are preparing companies that are not US or UK companies, we rely so heavily on local counsel to instruct us and educate us about the values that those companies hold dear, because being authentic and staying true to your market and true to your values is equally important. So it's very important that when we are advising an organization about how a message might land in the UK or in the US, that Indian counsel, for example, is there to say, no, we cannot make that concession, or we cannot be seen, even in the UK, to be taking a particular stance, because that's inconsistent with how we resonate with our market back home in India. So it's a real team effort here, where you have the local lawyers and PR communications agencies helping the likes of Sam and me to advise effectively. And I think the other point I'd want to emphasize is that even within the same jurisdiction, you need a different approach according to what type of hearing you're in. And I was speaking to one of my clients about this, actually an Indian organization, who when they instructed me on something, they told me that when they had dealt with an issue similar previously, they had their normal, exceptionally impressive arbitration counsel helping them with something, who didn't take a different approach to the engagement with the Parliamentary Committee. They just played this as though it were an arbitration. And that's very different, because in court, there's a framework. In an arbitration, there's a framework. You have examination in chief, you have examination, you have re-examination. You set the topics of questioning by reference to the pleaded case. There are parameters, and there are norms where you would face an objection if you overstep. And you have a judge or an arbitrator who's a referee. So the witness has the protection of counsel and the judge, who can step in to object to questions and re-examine on critical issues if the way that the witness has said something isn't quite right. And so even with the press, in the press gallery in court, there's less risk of the media. The media is likely to be more considered about the way it reports on something. Whereas in a committee hearing, you have no referee, you have no counsel protection, no topic is off limits, and MPs are not subject to the same regulatory duties as counsel and a judge is. So, it is a bit of the Wild West, where these people have their own agenda and they want to drive that. And often they're not interested in what your answer is. What they want is the media soundbite that's going to make the headline in the Times the following day. And that's all they care about. So you have to be aware that that's their objective, and have some counsel about how you manage that risk.
Definitely. Thanks, Sam and Joanna.
Can I say something?
Yes, sir.
Yeah. I think what Joanna, you have said, ultimately that sums up everything. It is not the CEO is appearing before a court or before any governmental minister. It's a different kettle of fish. The Parliamentary Committee, comprising of all kinds of people, political parties, they have got their own political agenda. So obviously, only the bigger companies will be invited, and everywhere the politics will be involved. That is one. Second thing, Samuel very rightly say, theatrical approach, because all televised. So I want to perform before a television. So I got to be as much theatrical as possible. I am not bothered about what Joanna, you just now said, you are not interested what kind of, answers I am giving. You are interested that I must be able to, throw questions, put you down. So this theatrical approach. So therefore, I think a lawyer plays only, one part of the preparational angle. But what information to be shared and not shared. But if it is in a committee, private, no lawyer allowed, and then the CEO is grilled, the poor chap, he does not know what to say and what not to say. So I don't think Indian companies, with greatest of respect, they are prepared, to do that. Maybe as a firm, I know your firm is a very good firm. Maybe you can do some, some kind of taking sessions while you are traveling in India and tell them that this is the way. It is not some drama what we used to see in the television, that questions are being asked, and what you said is very important. Everything is within limit. Nothing is off limit. Any kind of questions can be answered, and how that can be asked and how those can be answered, lot of preparation is needed. It is not enough that I am very articulate, I know the subject, I know the information, but the strategy, the way I will be forced to get into some kind of trap, this is something I don't think Indian companies are very much aware of.
Definitely. Good point, Mr. Mukhopadhyay. Sam and Joanna, we look forward to your India trip and hope Vanita and I can be there to assist you with these trainings as well.
Would love that.
Yes, parallelly, let's look into this from the business side of things. And how companies think about risk across borders. Many organizations are structured country by country, but obviously, as we know, scrutiny and reputation don't always sort of behave that way. So my question is to you, Mr. Mukhopadhyay, wearing your GC hat at a global Indian company, when you assess reputational and regulatory risk across jurisdictions, do you still manage it largely country by country, or do you assume that risks will spill over from one jurisdiction to another?
You see, the answer is you should have your own corporate governance standard. And that standard cannot be developed country by country basis. Again, with respect for Nigeria, I can't have one standard. For UK, another standard. For EU, another standard. And of course, the mother of all countries, US, another standard. It cannot be. Ours is a large group. 200,000 people are working here. And we operate in more than 60 countries. And the group is more than 100 years old. So the very fact that we are still surviving, thriving, and expanding even after 100 years, unless and until you have got certain core values in your DNA, you won't be able to really sustain. And we have got 5 principles, on the basis of which the entire business foundation is set up and the way the business is done. So that will be my first point. Second point will be, once you say that these are my core values, I don't care whether any law is there or any law is not there. But as a group, this is our fundamentals. Say, for example, work we do, business, finally to give back to the society. It is not that to earn money, pocket it, give back to the society. This is one of the principles, like there are 4 more principles. So therefore, that is the core value coming from within. It is there in the DNA. So whether the law is there or not, we will follow. Second part of it is obviously the regulations, because these days, the reputation is so much and we face it all the time. I'll give you one small example, basically. We have a 7-star hotel near London's Trafalgar Square. It's a $1.5 billion investment has gone into it. And it's, operational. Raffles manages the hotel for the last 2 years. Now, suddenly one of the newspapers, they came up with the story that, the social housing where you have to invest money, only this much was invested in the social housing and these people are running a big hotel. Now, obviously, it damages the reputation. Although the law is different, the way social housing operates, investment being made, it's completely different. But it damages the organization. So in today's situation, you can't say that I am doing only what the law allows me to do. Even like Caesar's wife, you have to do something more than what the law really requires you to do. So reputation is extremely critical. So that's why if there is a televised, parliamentary committee, and if any corporate goes there, rightly, wrongly, they are exposed, basically, if it is a public hearing. So, yeah, it is important. Reputation is, today's situation, reputation is everything.
Understood. And, just building on that, my question to Ms. Vanita Bhargava is that from an external counsel perspective, what are the most common channels through which these kind of issues, that are spread across borders? And how do you help clients prepare so that they're not reacting in silos when the scrutiny sort of goes public?
So, Susannah, from an external counsel's perspective, the main point is that risk travels through predictable channels. And if you plan around those channels, you reduce surprises. So, the most common channels we see are four: public record and media. Hearings, inquiry reports, and committee exchanges create a public record that gets clipped, repeated, and amplified. Even a technically accurate answer can land badly if it is inconsistent with prior statements or missing context. Second, regulator to regulator coordination, especially on anti-corruption, sanctions, data privacy, product safety, and now AI governance. Regulators are increasingly aligned. Development in one jurisdiction often triggers information requests for parallel scrutiny elsewhere. Third is investors and counterparties, lenders, customers, and strategic partners treat reputational risk globally. A problem in one country can lead to diligence questions, contract pressure, or procurement decisions in another. Then fourth is the litigation and claimant activity. Claimant firms track hearings and inquiries closely. What is said publicly can become the basis for follow-on claims, complaints, or discovery strategies. So how can we as lawyers help clients be ready? We can help build the playbook before the crisis, roles, privilege protocol, document preservation, internal investigation steps, and communication guardrails. We can help create a defensible narrative grounded in evidence, one set of facts, one strategy tailored locally but consistent globally. We can prepare witnesses and leadership teams not to be evasive but to be accurate under pressure, avoid absolutes, avoid speculation, prevent contradictions. And we can coordinate across jurisdictions. Practical value is anticipating how a position taken in one place, will land elsewhere.
Thank you so much. And now that's a very good lead into the final substantive question I have. Joanna and Sam, building on what organizations need from external advisors, how do you think Jenner and Block can support Indian businesses operating internationally in either preparing for and responding to parliamentary and congressional hearings and investigations?
Well, as I said earlier, I think the important thing to note is that it's not a kind of either or. It's not Jenner and Block only or an equivalent of Jenner and Block. It's a team that you need, actually. And so I would say the very first thing is you have to have a firm that understands this is a multidisciplinary risk. And you need someone with a collaborative mindset who is going to understand and respect the value of the commercial team, the PR, communications advisors, the local legal team, etc., and who can bring all of that together. You obviously need a firm that understands the Westminster parliamentary system and Capitol Hill. And you also need advisors who can predict how testimony in London or testimony in Washington is likely to bring regulatory exposure in Brussels, because there's very often a link between the two. I think you need a global lens and a strategic lens, and that doesn't mean you need a global firm. It means you need a firm that understands that what happens in one place can have ramifications everywhere, including your home jurisdiction, and who can coordinate the messaging so that what you say in one country doesn't create problems for you in another country. So when we advise organizations, we always assess how will this statement that we propose to say play out before the US prosecutors or the UK regulators or the Indian government, or your investors who you're having multiple exchanges with? It's really important to have a very open mind so that you can understand the ramifications of taking a particular political stance in one jurisdiction. And I think having the expertise and the experience of what political lines will be taken. So more so in our DC team than our London team, because the US market works this way. But we have former congressional investigators who've worked in US politics before, who are able to say how these things tend to play out with the government of the moment. And here in London, for example, we've prepared multiple executives for high-profile public inquiries. We know what the questioners are thinking. We follow the parliamentary select committee agendas, and we understand what they're after, and therefore we can support with that too. And then the most important thing is a process that guides your preparation, and that intensive preparation on your part. So the way we tend to do that is provide multiple simulation sessions with progressively hostile questioning, teaching you when to answer briefly, when to elaborate, how to avoid perjuring yourselves. And in jurisdictions where the rules on lawyers assisting witnesses are more restrictive, will help you hone your key messages that you feel comfortable with without overstepping that line. So there are multiple things to think about, and I think it's really a question of making sure that your advisors have those multiple issues in their mind and don't look at things in too narrow a way. Sam, I don't know if you want to add anything.
No, I think I couldn't agree with everything that you said more. The only other thing that I will say is, it's oftentimes we get called in the middle of a crisis, right? When someone's been summoned for a hearing, or when a hostile letter has been sent, and we go through this very, very intensive process, and we love doing it. It's really, we love helping our clients through those hard moments. But I can't stress enough, the value of what Joe said earlier, which is, adding this to your risk register and starting to think about it before you are in that crisis moment. Make sure you have a team that is assembled, that covers all of those disciplines. We love working with smart PR people and smart government affairs, folks, and folks on the business side, folks in the executive suite, to hone those messages before the risk, that we anticipate manifest, so that we're ready to go, rather than scrambling at the last minute when a subpoena, or a demand for testimony comes in. And it's hard to think about, or even to motivate, when such a thing can seem so remote. But it's better to do it earlier, because risks that may seem remote, once they come in, become these matters of enormous urgency. And it's just better to have that plan ready to go in your drawer, so you can deploy it when the moment comes.
Definitely, as an investigations lawyer myself, I cannot stress enough that preparation is much better than eventually dealing with it last moment. Before we close, I'll just ask you for one final thought. If you had to leave the audience with one or two or three practical takeaways, what should Indian companies be asking themselves now to be better prepared?
Yeah, it's a very good question. So I would say, first of all, ask yourself, are we in sectors that are under heightened scrutiny by US or UK or EU legislatures? So technology, pharma, manufacturing, anyone with a complex supply chain operating globally. I think they're the kind of main ones. We can't rule out all the others, but these are the ones that are currently getting the scrutiny. Then the next question, do we have operations or significant customers in the US, the UK, or the EU? If you do, put this as a risk register, have your board talking about these things, follow the select committee or congressional agenda, understand what the topics are. And then finally, understand if any of the companies in your industry have been called to testify recently. So we mentioned a few earlier, but in the US and the UK, in the main, they are the pharma sector on safety, pricing, supply chain integrity, the technology sector on data protection, AI ethics, content moderation, labor practices, manufacturing, supply chain, labour standards, environmental compliance, and then financial services also, so money laundering, sanctions, fintech regulation. These are the topics that we're seeing a lot of activity around. So I would say ask yourselves those questions, and if you fall within any of those categories, then this is something that really should be on your radar and you should start to think about preparing for.
Oh. So that's the end of our panel discussion. Thank you so much, everyone. This was a very, very good discussion. It was very insightful. We are now opening the session to questions from the audience. So audience, this is your time to shine. Does anyone have any questions for our panelists? How will we get to know if somebody has a question? I'm just trying to figure that out. Neeluji, will someone be posting the questions on our chat?
While we wait for questions, I should add that we have prepared a slide deck that distills some of the key points that we've made in this webinar. So I guess the IACC can circulate that to the attendees after this session. But that will give you a little bit of an insight or a reminder of the sectors that are most affected and the types of questions you should be asking yourselves, and some of the kind of points that we've made about the consequences of these types of hearings. So hopefully you'll find that a useful resource.
Yes, and I think the profiles for all the panelists have already been circulated. What we can do is that we can circulate the email IDs as well, so that if anybody has any questions, comments, potential matters, something we love, please feel free to reach out to us directly, and that will be amazing. So it seems like we don't have any questions, which means this is the end of the session. Thank you everyone so much for joining. It was very, very insightful. And yeah, good evening from Singapore, and good night to all of you.
Thank you so
Thank
much
you.
for having
Thank you
us.
so much.
Thank you all so much. Really appreciate it.
Thank you so
Thank
much.
you.
Thank you.
Bye-bye.